like to pathologize whistleblowers, which I know the media is quick to do. I don't know how whistleblowing has gotten such a dirty name of being people who are out for fame or profit or revenge, because all the whistleblowers I've worked with have been regular people. I wouldn't describe them as shrinking violets. They're usually outspoken people who have a good sense of who they are and their place in an organization and the limits of what an organization can and should be doing. I think every person in themselves has a squeal point of something where they can no longer endure witnessing it. Now, I mean, on a very basic level, if you see an old lady being mugged, you'd probably dial 911 on your cell phone and make a police report. Well, that's whistleblowing. In my office, in the ethics office, we took turns being the duty attorney for the day. And it was just random that I happened to be the ethics officer on desk when I got a call from the criminal division of the same Justice Department saying that the FBI was on the ground and wanted to interrogate an American who was being called the American Taliban. It was all over the news, and wanted to interrogate him. And I was told matter-of-factly that he had a lawyer. So in accordance with the advice we always gave in this kind of situation, I said, you can't do that. He's an American, he's represented by counsel, but here are some other ways you can properly be able to do that. You could do an undercover, you could try to get a waiver. I mean, there are different ways that you could properly do this, in different alternatives to try to talk to him. And that was on a Friday. So the advice I gave was not unique, really. The case happened to be a high-profile one, but the advice was what I would normally give to any department attorney who had an agent on the ground who wanted to do something. And the same person who called me called back on Monday, 2 days later, saying, well, they interrogated him anyway. Despite your advice, the FBI interrogated the American Taliban, John Walker Lind. What should we do now? And again, I said, don't panic. I mean, this happens that people disregard our advice or they make an ethical blunder and we need to help try to fix it. So I said, look, you can seal that interview and you can use it for national security and intelligence gathering purposes, but not for criminal prosecution. And they seemed fine with that answer. And they were going to communicate that to the military on the ground and the FBI agents who had interrogated him. But then sometime, maybe a month or so later, John Ashcroft, who was the Attorney General at the time, he was very fond of these very dramatic press conferences, and he gave one announcing that they were going to charge John Walker Lind, and a reporter said, I heard he had a lawyer. Was he able to have his lawyer with him? And Ashcroft said, if we knew that he was represented by counsel, he would be allowed to meet with that lawyer. And I knew that was a flat-out lie. But again, he was the Attorney General, so it was his prerogative to say what he wanted. And I kept my mouth shut. And then a couple of weeks later, he had another press conference on the same topic. And by this point, there were pictures circulating around the world of John Walker Lind naked, blindfolded, bound to a board, gagged with epithets written all over his forehead. And it looked very reminiscent of what we later would see at Abu Ghraib. It was clear that he was being tortured. And so a reporter asked, it looks like this guy's being tortured, what's going on? And again, the Attorney General said that his rights had been carefully, scrupulously guarded. Again, I knew that was a complete lie because they had actually committed an ethics violation, and it sure didn't look like he was being treated very well. But again, I kept my mouth shut, and they filed a criminal case against him, which I had advised them not to do. They did the exact opposite. The thing that bothered me as the case progressed was that it all came down to a suppression hearing that he was going to have. The crux of the case was his confession during his interrogation, the one I had advised against. And on March 7th, that was a pivotal day for me, because the prosecutor himself emailed me and said, as you know, there's a federal court discovery order for all Justice Department correspondence related to John Walker Lynn's interrogation. I have 2 of your emails, and I wanted to make sure I have everything. And at that point, I was alarmed because I knew I had written way more than 2 emails, but I was still naive about it. And I went up and checked the hard copy file. And that's when my heart really sank. I checked the file and it was empty except for 2 very innocuous pieces of paper, and it had been about 1 inch thick. And at that point I felt like, okay, something really bad is going on. So I consulted with a senior attorney who had been a U.S. attorney for 7 years. And I said, what's going on here? And he just told me, he looked through the file and said very matter-of-factly, this file has been purged. And I'm like, what? That it completely threw me for a loop because we were simultaneously prosecuting Arthur Anderson and Enron for destruction of evidence and obstruction of justice. And the idea that the department could actually get rid of evidence in violation of a court order, no less, was unthinkable to me. At that point, I confronted my boss. She came in and I said, Claudia, there's a discovery order and no one told me about it. And apparently it has not been complied with because the prosecutor only has 2 of my emails. And she just glared at me and said very matter-of-factly, I sent everything that was in the file. And at that point, now she's connecting herself to this. I mean, she is admitting that she's involved in this and handled the file. And I just said, I wrote more emails than that. And I didn't quite know what to do, but I knew I didn't want to be a part of this. And I called my husband because he was a contractor at the time. And I was like, look, something really, really, really unseemly is going on here. And you need to get a permanent position because I think I'm going to resign. It's that bad. Like, I don't want to be a part of this. And I mean, it did feel monumental to me. And I called up technical support. This is early in the digital age, in its infancy at the department. And I said, look, I had all these emails. I, put them in the trash and emptied my trash on the computer, and they delete off the computer every 30 days, so I probably can't get them back, right? And they're like, oh no, we can get them back. Nothing disappears. And we spent hours going through these different ballet steps to try to recover them. And I was able to recover about a dozen emails. I know I had written more than that, but a dozen that had the documentation that the FBI had screwed up and committed an ethics violation in its interrogation of John Walker Lindh. So I documented the 2 pieces of paper in the file, and I put in order all of the other emails and essentially like a bullet about what they said, and attached copies, wrote a memo to my boss to document that, and then I Xeroxed a copy of it to take home with me in case the emails disappeared again. And you took it to my boss, and she seemed infuriated that I had done this. She's like, why weren't these in the file? I was kind of like, you tell me, Claudia, why weren't they in the file? And I said, you know what? I am not even going to be a part of whatever game you're running here. I'm resigning. You have 2 weeks, my 2 weeks notice in, and I'm resigning. I got a job at at a law firm, a private law firm, doing something totally unrelated to anything I was trained in. I was doing affordable housing law, but I thought, okay, socially redeeming work and a bigger paycheck. But I continued on the radio to hear things about the John Walker Lindh criminal case as it was progressing. And the things I was hearing on the radio said to me that, John Walker Lindh never had counsel, and statements that, his rights were by the book, followed. Things that I knew were patently untrue, and that told me if my emails had in fact made it to the judge, I don't think the department would have the temerity to be making statements like that. And it weighed very heavily on me. I mean, I was a raging insomniac. I could not sleep. The guy, he had like 3 life counts on him, and it was a feeling of like, man, someone could be put to death because I kept my mouth shut. And that is a really, for me, that's the line. I mean, that's something I couldn't live with. For me, that was, my moment. One morning, I heard Mike Isikoff of Newsweek saying that, he never had counsel, that's not an issue. And I called Mike Isikoff and I said, I don't know who's telling you this line of bullshit, but I have evidence to prove that it's wrong. Before that, I had gone to the judge to try to give him the emails, but I no longer worked at the department, and I was told by his clerks I no longer had standing. By the time I called Mike, I was just like, you can't keep saying this. And I showed him the emails, and he said he would write an article on it, which he did. He asked if I wanted to be named in the article, which I did not. I wanted to be anonymous. So he wrote a really good article that actually ended up causing the ultimate collapse of the John Walker Lindh case. But meanwhile, Newsweek put up all of my emails with my name on their new website. So it was like a big red arrow pointing right at me. And so that really ended up, I think by blowing the whistle, I thought it was over with. Like, okay, I've done my part. I can sleep again. I can live with myself. And whatever happens, happens. But I didn't realize I had just unleashed the full force of the entire executive branch. And they came and they told my new law firm that I was a criminal, that I would steal new files, protected files, and that they should fire me. They leaned on a private law firm to fire me, which the law firm wouldn't do, but they put me on this weird administrative, unpaid, indefinite administrative leave. And it was like being in purgatory. Meanwhile, you know, the Justice Department, I hire a lawyer and the Justice Department starts making noises about a criminal investigation and that they were putting me under criminal investigation for leaking, which is the first criminal leak investigation I know of since maybe Ellsberg's, for someone who didn't reveal non-spy activity. I had done a research memo during my time working in the ethics office on whistleblower protection laws, so I knew what they said, and I knew that going to the media was an option, going to Congress was an option. I'd already been to my superior and to the prosecutor saying something fishy is going on. I knew that I had, I met the standard. I had a reasonable belief that what I was witnessing evidenced fraud, waste, abuse, or illegality, or danger to public health and safety. And so within that understanding, I blew the whistle. What didn't dawn upon me was that the Whistleblower Protection Act is a paper tiger. It has no enforcement mechanism. So when the government starts retaliating against you in spades, there's really nothing you can do to make it stop. And the retaliation began with them trying to get me fired from my law firm. The law firm being, playing both sides of the street, cooperating with the government, yet at the same time claiming I still work there, but not letting me do any work. Then petty little things like the government actually helped the law firm contest my receipt of my meager, pathetic unemployment benefits, which I was entitled to because I was no longer getting an income. So I filed for uninsurance, which was pretty humiliating for me. But really, you're going to contest my, big $300 a week I get to buy gas and groceries? That petty, though. And as soon as one thing ended, another would begin. So finally, once the criminal case ended on September 11th, ironically, of 2003, it ended with no charges being brought. But within days, the department had referred me to the state bars in which I'm licensed as an attorney in both Maryland and DC. So now I had to fight on another front. And all of these fights cost a lot of money because I had a private attorney who was billing at a very high rate, upwards of $1,000. Then I had to have another attorney, an employment attorney, dealing with the law firm, which was giving me grief, which kept claiming I was still employed there, but was not paying me. So it was a mess. And the bar referrals, that was a whole other attorney I needed for that, to deal with the DC and Maryland bars. The complaint against me in DC lasted until this past summer, 10 years before it got dismissed. And that was only because 2 of the major players died. And then also during that time, I found that I was on the no-fly list, on the selectee portion of the no-fly list, meaning you get hassled and have to undergo secondary security screening every time you fly. Again, that was just an inconvenience and a way to intimidate and harass and delay and mess with you, basically. The government has amazing and just a whole panoply of things it can do to screw with whistleblowers. Lind ended up pleading guilty in a surprise plea bargain deal on the eve of the suppression hearing that was going to bring out into the open who did what to him and who broke what rules, the stuff that I had advised about. So it collapsed. He pled guilty to 2 minor administrative infractions and was overpunished with 20 years in jail for that. So his case ended. Again, I thought, okay, the end of my ordeal, but my ordeal continued for another 3 or 4 years. And at that point, I decided I was going to dedicate my life to representing whistleblowers, because clearly they were a group that did not have the protection that they needed. I mean, it was my personal experiences and at that same time meeting a few other whistleblowers who were going through similar things and thinking, okay, I want to do this kind of work because for better or for worse, I've learned it by going through what I've gone through. I've learned whistleblower law. So I ended up working for Alan Grayson, who is congressman now, but at the time working at his firm, going after people who were blowing the whistle on Reconstruction fraud in Iraq. And I did that for 2 years. So that was sort of poetic justice. And then I was elected to the DC Bar Legal Ethics Committee, so that was more justice. Me, who doesn't know legal ethics or understand it, got elected to that board. And then an opening, Alan got elected to Congress, and an opening occurred at the Government Accountability Project to head up a new national security human rights program, which was an ideal fit for what I was doing. I was doing pro bono work on behalf of Guantanamo detainees and writing articles about legal ethics and how it meshes with the war on terrorism. So it was great at GAP, but I thought I would be dealing more with kind of the bread and butter whistleblower cases where people get demoted or they've been, they've had their security clearance pulled or, at worst, maybe they've been fired. And there were a number of cases I did like that at first. But then I read about this guy, Thomas Drake, and everything I read described him behavior as a whistleblower. It described exactly what a whistleblower would do. And he got indicted. And at that point, I knew we had crossed a Rubicon into a new age if we were going to criminally prosecute whistleblowers and do so for espionage, a law meant to go after spies, not whistleblowers. And so my practice has developed into representing, unfortunately, a long list of people right now who've been charged, who have been investigated or charged under the Espionage Act. The Espionage Act is this long, antiquated, overbroad, extremely vague act that, when it was written in 1917, it didn't even, that's decades before the word classified even entered the lexicon. So they're talking about war materials and designs and boat designs and films and, it was completely antiquated, but really it was meant to go after spies and not people who were trying to do the right thing. So the fact that that was being used was very heavy-handed and very dangerous. Certainly concerned me. And I definitely worried about the fact that this had happened to Tom. I was hoping it was just a serious one-off and then it wouldn't happen again, but now it's happened 7 or 8 times. But because of my experience with Tom, I continue to represent other whistleblowers who had been charged under the Espionage Act and continue to do so today. we go forward by insisting in these surveillance reforms that there be whistleblower protection in them. You need to have an enforcement mechanism. I would say jury trials. I want jury trials for these cases so people can see what goes on. Jury trials in federal court, not in toy court, not in these made-up little administrative, processes they have. These toy courts are joke courts. I mean, you need to be in a real federal court. That would be my suggestion.